Hello, Dami, are we on? Are we on? Are we on?
Yes,
wow. Hey, Jerry, good afternoon. Oh, thank you. Wow. Understandable. One of our committee members, Jerry, he's joining from Luxembourg, Jeremiah Sondoibo. Thank you, Jerry, for keeping in touch. This means a lot to the committee. Thank you, sir. Okay, good afternoon, esteemed participants. My name is Ebenezer Eguatu. I currently serve as the chairman of the Medical and Health Law Committee, and I will humbly welcome you all to today's webinar in commemoration of the World Patient Safety Day 2025. We will just give a few minutes. So far, we are only 42 on the call. We'll just give like 10, maximum 5-10 minutes for other colleagues to hop in, and we kickstart the webinar in earnest. Thank you very much. Mr. Blessing, good afternoon, sir. We are highly honored to have you on this call. You have been following up since. Thank you, sir. Prof, you may join. Please, sir, join. Prof, you may join. Join on the Zoom. It hasn't filled up yet. Thank you, sir. Okay, good afternoon, everyone, and welcome to today's webinar. We are indeed glad to have you all here. So far, we have 59 persons on the call, and by my time from this end, it is exactly 6 minutes past 3. So we will just be patient for the next 4 minutes to have more of our colleagues join, and we kickstart. But while we wait, let me just brief those who might be joining us for the first time on who we are and why we do what we do. Okay, this is a webinar organized by the Medical and Health Law Committee of the Nigerian Bar Association, Gariki branch. This committee was set up with the sole purpose, or rather among other reasons, to empower our colleagues in the area of medical and health law practice through capacity building. So far, the committee has been consistent in hosting monthly webinars since this year, barring the months of February and March due to technical reasons. Apart from those 2 months, we have been consistent in having our monthly webinars. We have had webinars on topics such as surrogacy. We have looked at emergency treatment and the law. We have looked at the use of alternative dispute resolution in resolving or in settling doctor-patient disputes. We have looked at strengthening healthcare policies. We have also looked at organ donation, specifically kidney, legal and medical perspective. And we have looked at mental health too, focusing on lawyers. So today, being the 18th day of September 2025, we want to focus on the rights of patients, understanding patients' rights. And the primary reason for the choice of this topic is because the month of September is designated by the World Health Association, specifically 17th day of September is designated by the World Health Association as World Patient Safety Day, a day kept aside by the organization to draw attention and awareness to issues around medical harm and see how it could be prevented. So the first World Patient Safety Day held in 2019, 2020, 2021, 2022. On our own part as a committee, we joined the train in 2023 by doing specific activities to mark the day. 2024, we repeated the same. And today, we are saying that we want to go into knowledge sharing for this year's World Patient Safety Day. So this year, the theme for this year is safe care for every newborn and every child. The focus is actually on newborn and children. However, we decided to stretch the topic a little by looking at all classes of patients. That's why we chose to discuss understanding patients' rights and the legal remedies in Nigeria. A lot of people do not know that there is something called patient rights. A lot of persons know, but they confuse it with human rights. Where there are violations of these rights, they do not know where to complain, how to complain, and all that. Are there even remedies in law? Those are the things we are going to be looking at between today and tomorrow. So at the proper time, we will start the lecture. I think it is exactly 10 minutes past 3, and I want to introduce or hand over at this juncture to the moderator of this webinar today in the person of Dr. Amarachukwu Ezetulugo. Thank you, Doctor. Over to you. Good afternoon.
Thank you so much, the chairman of the Medical and Health Law Committee of the MBA Abuja Gariki branch. A very good afternoon to you all, distinguished local and international participants. I welcome you all to the September edition of the Medical and Health Law Committee webinar of the Nigerian Bar Association Gariki branch. This month's webinar promises to be educative and insightful. I urge us all to sit back, relax, and I promise you must learn one thing today. This month's webinar is in commemoration of the World Patient Safety Day 2025, and this webinar is slated for 2 days. Today, the 18th day of September 2025, and tomorrow, the 19th day of September 2025. I will be the moderator for today. My name is Dr. Amarachukwu Ezetulugu. Distinguished participants, let me quickly inform us that while the presentation is going on, feel free to drop your questions in the chat box. At the end of the presentation, all the questions will be taken and answers given accordingly. Also, in due course, the CPD link will be displayed to enable participants fill out their forms and earn their CPD points. Distinguished participants, our speaker for today is a familiar face, a medical law expert, someone who is vast in medical law practice. But before I proceed to read the profile of our speaker, join me, distinguished participants, to welcome the branch chairman of the MBA Abuja Gariki branch, Mr. Anthony Bamidele Ojo, as he delivers his welcome address. Mr. Anthony, let's have you, please. Thank you. Hello, Mr. Anthony. Can we have you deliver your welcome address?
I hope he's
Can you
still
hear
on
me?
the call.
Yes, I am here. I was having some technical issues. Good afternoon, distinguished ladies and gentlemen. Good afternoon, moderator. Good afternoon, the chairman of the Medical and Health Committee of the branch. Good afternoon, our esteemed branch members. Good afternoon, members or non-members of the branch and non-lawyers. I want to most specially and most respectfully welcome everyone to this morning that will help widen and expand the horizon of our members in the area of medical and health law. So I want to welcome everyone and ask that everyone should be fully attentive in participating in this webinar. We are going to learn much and we're going to learn a whole lot. Thank you very much as we participate for today and for tomorrow's sessions. Thank you and have a wonderful time.
Thank you so much, Mr. Anthony Bamidele Ojo, the branch chairman of the MBA Abuja Gariki branch, for that beautiful welcome address. Distinguished participants, our speaker for today is no other person than the chairman of the Medical and Health Law Committee of the MBA Abuja Gariki branch, in the person of Ebenezer Egwatu. Ebenezer Egwatu is a legal practitioner, medical law consultant, certified mediator, trained legislative drafter, and a passionate patient rights and safety advocate. He is the principal partner, Law Front Multidisciplinary Consults, a law firm that provides innovative legal solutions located in Abuja, FCT, Nigeria. He is the founder and executive director of Lawyers Arise for People Initiative, a patients' rights and safety advocacy NGO, as well as Safe Health Medical Legal Consult Limited, a consultancy and capacity building firm. He is a member of the Nigerian Bar Association, member, Medical Law Professional Association of Nigeria, member, Institute of Medical and Health Law, member, Bioethics Society of Nigeria, member, World Association for Medical Law, and member Association of Legislative Drafters and Advocacy Practitioners. Ebenezer is a trained medical care assessor by International Medical Law Center, St. Kitts, North America, 2019. He also has a certificate in policy development and advocacy for global health in 2021, and certificate in project management in global health also in 2021, both from the University of Washington. In 2016, he served as associate editor of the book, Patients' Rights Violation in Nigeria, a Dex review of health-related laws in Nigeria in 2023. He served on the committee that fine-tuned the National Patient Safety and Care Quality Policy and Implementation Strategy in 2024, which was launched by the Federal Ministry of Health and Social Welfare on 17 September 2024. Through his NGO, he has trained over 120 nurses, over 200 doctors, and over 180 nursing and midwifery students on promoting patients' rights and preventing medical negligence. He currently serves as the chairman, Medical and Health Law Committee, Nigerian Bar Association, Gariki Branch, Abuja, the Public Relations Officer, Institute of Medical and Health Law, the Secretary, Training Committee, Institute of Medical and Health Law, and the legal team lead for Make Our Hospital Work campaign, a citizen-led community-based advocacy to improve the quality of healthcare services in hospitals and primary healthcare facilities across Nigeria. Ebenezer is a conference speaker and trainer. He trains doctors, nurses, and other healthcare professionals on patient-centered care, promoting patients' rights and safety, and preventing medical negligence, and protecting health institutions. He is a reader, a researcher, and loves to serve God by serving humanity. Distinguished participants, join me to welcome Ebenezer Egwatu. Let's have you make your presentation. Thank you.
Thank you, Madam Moderator. Please kindly confirm if you can see my camera. Am I visible on the screen? I doubt if I can see myself.
Yes,
okay.
Sir, I can see you.
Thank you very much. Thank you. I want to thank the chairman of Gariki branch of the MBA in the person of Anthony Bamidele Ojo Esquire for the support he has given this committee. I sincerely doubt if there is any other committee within the branch that has received that unfettered support from the branch executive. Chairman, we are grateful, sir. I also want to salute a few of my ogas here. I'm aware that some of them are on YouTube also. I want to thank Mr. Chidi Dimba. I want to thank Professor Osimen Clements. Prof, good afternoon. Thank you for joining all the way from outside the country. I want to also thank one of our staunch committee members, Jeremiah Oyibo, who is also joining from out of the country, and a host of others. Professor Cheluchi, thank you very much for joining. Dr. Zainab, thank you. The list goes on and on and on. I want to finally thank the committee for granting me the rare privilege to sit before us today and share what we are about to hear in terms of understanding patients' rights and the legal remedies in Nigeria. So, having said that, we will go straight into sharing of the slides. Just give me a few seconds to get that sorted. Okay. Is it on now? Can you see it?
Not yet.
Oh, sorry. Okay, can you see it now?
Not yet.
Wow. Can you see?
Not yet.
Oh, so what could be the challenge now? Because I'm already here. Okay, let me start all over. Can you see now?
No, sir.
Oh, this is a strange, but we did earlier. Okay. Just a moment, please. Okay, I think to save our time, let me just proceed, and I will forward the slides to the technical people so that while I proceed, they can sort the sharing, if that works. But I don't know. We had shared before. I don't know why it's not coming up.
It showed earlier, but
That
disappeared.
again, as I started now.
No, not recently anyway.
Okay.
Yes.
Let me try for the last time, and if it doesn't work out, I will send it to. Show slides, yeah. Okay, let me forward it to the technical people. Sincere apologies for that. I have no explanation for this actually. Okay, that has been done. While they sort the sharing, let me proceed because of our time. Good afternoon, esteemed participants. It is my singular privilege and honor to be sharing this with us this afternoon. We are discussing understanding patients' rights and legal remedies in Nigeria. Like I said earlier, a lot of people do not know that patients have rights. A lot of people do not know that these rights are enforceable. And if you close your eyes, in fact, let's start from there. Just close your eyes for 2-3 seconds or for 5 seconds. If you have done that, I will want somebody after 5 seconds, think within these 5 seconds. If you do not remember anyone you know directly or indirectly, or you have heard that the person went to hospital and didn't make it back alive as a result of negligence or as a result of violation of patient's rights, just type "I did not remember one" on the chat box. For the end of 5 seconds, you do not have one name you know. You do not know somebody, brother, whose sister went to hospital and did not make it back alive. As a result, please get the qualification, as a result of either negligence or violation of the person's right as a patient. Just type on the chat box, "I did not remember" or "I do not remember any." But if you remember, of course, if I do not see chats, I am looking at it, I can't see anybody saying he or she does not remember. That means we are all familiar somehow with the issue of patients and healthcare professionals. So the content we are going to be looking at today: definition of a patient, definition of patient's rights, identifying various sources of patients' rights in Nigeria or globally. Then we examine different patients' rights that are enforceable or applicable in Nigeria. Then we look at we will highlight conduct that constitute violation of patients' rights. Then we will also examine available redress mechanisms in the event of violation. And finally, we will look at legal remedies available to these patients whose rights have been violated. I have always maintained that all of us are potential patients. So you might not say, you might say, "God forbid, it will not be my portion." We agree, and I say a big amen to your prayer. However, the reality is that from birth till now, you have at one point or the other sought medical care, either in the orthodox medicine regime or through alternative medicine. Even when you are treating yourself at home, you are still a patient. So having said that, let us go straight to who a patient is. Who is a patient? A patient is a person who receives medical care or treatment from healthcare professionals, such as a doctor, a nurse, a therapist. We all know a person who receives medical care. The person may seek medical care for a wide range of reasons. It could be because of illness or injury. It could be routine checkups. It could be preventive care. It could be chronic medical condition management. It could be mental health support. It could be surgery procedure or rehabilitation. So while the person is seeking care, the person is a patient. In a broader sense, a patient can be anyone under the care of a medical or healthcare system, whether in the hospital, clinic, home setting, or virtually, because we now have telemedicine. So you might not say, "I didn't go to the hospital." Over the phone, you can receive a medical guidance and sometimes prescriptions or examination electronically. So you are still a patient. Now, the approach I have adopted in delivering this webinar, because we said understanding, so I have put in a lot of content. So it will not be rushed. Just be patient and you will get the gist. Who is a patient? The National Health Act under section 64 uses the term user to describe a patient. So user under the act means the person receiving treatment in a health establishment, including blood or blood products, or using health services, and if the person receiving treatment or using health services is below the majority age. User includes the person's parents or guardian, or another person authorized by law to act on the first mentioned person's name, that's on the minor's behalf, or incapable of decision. User also includes the person's spouse, that's a matured, an adult patient's spouse.
Sorry to interrupt, Mr. Ebenezer. Can you see the screen now?
Okay, let me check.
No,
Yes,
I mean
I can see.
Okay.
Yes,
right.
yes.
I can
So
see.
let's go to the next slide. Thank you very much. Okay, I was saying that, go to the next slide. We have defined who a patient is, and we are zeroing in on the provisions of the National Health Act, specifically section 64, which is the interpretation section. Now, the National Health Act defines a patient, or uses the term user to define who a patient is. We have earlier said that a patient is a person seeking care or receiving care. Now, the National Health Act is telling us other broader categorizations of who a patient could be. And we stopped at a matured adult patient's spouse. Then it continues, B, in the absence of a spouse, the person's parents, grandparents, adult child, brother, sister, or another. Now, the scenario here is there's a matured man whose wife is not available as a care provider within the hospital environment, and the person's father or adult son or brother or sister is there providing care or assisting. So the act contemplates these persons as users, meaning these other persons could also be called patients, even though they are not receiving direct medical care by themselves. C, persons authorized by law to act on the first mentioned person's behalf. So for the purpose of this webinar, okay, let me explain the third one. Now, where someone is incompetent to make decision and someone has been appointed, that person that has been appointed by law or authorized by law to make decisions on behalf of the person receiving care, the primary patient, can also be referred to as user, or the act has actually called the person a user of course, the hospital facility or the healthcare facility. So for the purpose of this webinar, we will restrict patients or user. We will restrict our word, or we will use them interchangeably as used in the National Health Act to mean a person receiving medical treatment in a health facility, clinic, home setting, or virtually, whether for illness or injury, routine checkups, or preventive care, chronic condition management, mental health support, surgical procedure, or rehabilitation. So when you hear patients, this is the person we are referring to. Next slide, please. Now, patients' rights, what does it mean? We say patients' rights are the ethical and legal principles that protect individuals receiving care, ensuring they are treated with respect, provided with necessary information, and empowered to make informed decisions about their care. These rights are fundamental to a patient-centered approach to healthcare and promote a safe and supportive environment. Now, we are talking about what patients' rights are. We have seen who a patient is. So what rights do they have? And this definition is telling us that they are ethical and legal principles that protect the caregiving to the patient by the healthcare professionals. Now, I personally grappled with a decision, or sorry, a definition for patients' rights for years. The researches I made, I discovered that there were more like listing the rights itself. You do some research, you see patients' rights include right to informed consent, right to privacy, right to confidentiality. Now, that is not a definition. So I tried then on my own, this should be 2019, I came up with this decision, this definition. Patients' rights are those rights that guarantee professional, quality, transparent, and safe healthcare delivery to a patient, as well as respect for the dignity of the person of the patient by healthcare professionals while providing healthcare services to the patients. Now, you notice that a few words are underlined. One, professional. So patient's rights must guarantee the patient that the patient will receive a professional care, that the patient will receive quality care. So you can receive a professional care because the care you're receiving is being provided by a professional, a doctor, a nurse, a lab scientist, but that care might not be qualitative. That care could be substandard. So a patient's right must guarantee professional care, quality care, transparent care. When we talk about transparent care, it goes even to your information, to your billing, to helping you decision making. You will be the one making decisions for yourself after you have been provided relevant information. So the care should not be shrouded in mystery. You should not be in a position where you do not understand what is going on. A patient right should also guarantee you a safe care or safe healthcare delivery. Then, more importantly, a patient's right should guarantee you respect for the dignity of your person. So if you're receiving a professional, transparent, and quality and safe care, and you are being abused while receiving that care, you are being stripped of your dignity while receiving that care, your right is being violated. So that right is not complete. Next slide, please. Okay, what are the sources of patients' rights? Now, this particular segment is very interesting and important because patients' rights didn't fall from the sky. There are documented sources. We look at the Universal Declaration, we have international conventions and treaties. First, the Universal Declaration of Human Rights is there. Look at Articles 1, Article 3 and 5. Look at the Declaration of Geneva, that's the Hippocratic Oath. Every doctor upon induction swears to this oath. Every doctor you know today has been administered this oath. And it is guiding them on how to carry out their profession or professional duties. So the Hippocratic Oath was adopted by the World Medical Assembly 1948. The latest version is the 2017 version. It has undergone several amendments and review over the years. Next slide, please. Okay, we have International Convention on International Covenant on Economic and Social Cultural Rights. Look at section 12.1. It guarantees the right of everyone to enjoyment of the highest attainable standard of physical health. You look at section 12.2. It mandates states to take steps to reduce stillbirth and infant mortality rates, improve all aspects of environmental and industrial hygiene, prevent, treat, and control epidemic, occupational, and other diseases. and the creation of conditions which would assure to all medical services and medical attention in the event of sickness. Our country is supposed to put measures in place to ensure that in the event of sickness, you will receive medical attention. And Nigeria is a signatory to these conventions. We are talking about international conventions and treaties. The Helsinki Declaration of 1964 is there. It was the first international document setting out the rules for medical experiments with humans and research ethics and informed consent. It has also become a strong tool for protecting patient autonomy because the patient or the subject has to consent to that experiment now. Then, at first, it was meant to protect against unwarranted inclusion in experiments, but it has now become a general accepted standard. We will soon get to informed consent. This is where it started. Next slide, please. Declaration of Tokyo, 1975. It sets out guidelines for physicians concerning torture and other cruel, degrading treatment or punishments, defines torture as the deliberate, systematic or wanton infliction of mental suffering. Then emphasizes that physicians should not participate in or condone. Sorry, excuse me, I'm having something blocking my screen. Okay. Physicians should not participate in, condone, or facilitate torture or other cruel practices. The declaration condemns medical participation in torture and cruel, inhuman, or degrading treatments, or acts to diminish the ability of the victim to resist such treatments. It was passed in 1975 and has undergone several revisions, with the current one being the 2006 version. Now, there are few pillars of medical ethics. One of the cardinal pillars of medical ethics is the principle of non-malfeasance, the principle of do no harm. So where a doctor is participating actively to cause harm to a patient, it is a violation of the doctor's oath to do no harm to patients. Next, please. And again, the principle of beneficence requires the doctor or healthcare professional to act in the best interest of his patients. So when a doctor is actively collaborating or with any authority to bring harm to a patient or torture or cruelty to a patient, is a violation of the Hippocratic Oath and the principle of beneficence. So another source, still under international treaties, Lisbon Declaration. This was the first major effort at codification of patients' rights in a single document. It turned the paradigm of health as an aspirational aim to an individual right of each and every person. So prior to coming into existence of Lisbon Declaration, patients' rights were not codified. It was within the breast of the doctor or the healthcare professional. If he decides to respect it, so be it. The patient can demand, but you are not holding anything tangible to say, this is what entitles me to this right. It was from Lisbon Declaration that we began to have patients' rights documented. And it was no longer an aspiration. It was no longer what we are wishing to achieve or attain. It became a right that individuals can lay claim to. Part of the preamble places a responsibility on physicians to pursue appropriate means to assure or restore these rights of the patient whenever legislation, government action, or any other administration or institution denies patients these rights. So Lisbon Declaration confers on doctors a responsibility to protect patients' rights, even against the position of established institutions or governments. Next slide, please. We come to African Charter and People's Rights. This is coming home. Article 5 recognizes the right and dignity, the right to dignity of human person, which includes patients' freedom and freedom from torture, cruel, inhuman, or degrading treatment. Article 6 recognizes the patient's right to personal liberty and security of his or her person. It guarantees patients' right to freedom from unlawful detention. We'll still look at that. The unlawful detention of patients by some hospitals for non-payment of hospital bills is a violation of Article 6 of the African Charter. And we also now have judicial pronouncements that concur with this position. Article 16 recognizes the enjoyment of the best attainable state of physical or mental health as a right. State parties are under mandatory obligation to take necessary measures to protect the health of people and ensure that they receive medical attention when sick. Now, these are obligations of the government. And next slide, please. So, when the government is providing measures, it is not a favor. They are fulfilling their obligations. So, we come to domestic legislations. We have looked at international covenants and treaties. We are looking at domestic legislations. So the 1999 Constitution, Chapter 4 is there. The National Health Act 2014, HIV and AIDS Anti-Discrimination Act 2014, Compulsory Treatment and Care for Victims of Gunshots Act 2017, the Mental Health Act is there. The National Health Insurance Authority Act is there. So all the acts that I didn't put on that are related or provides governs healthcare service delivery. If you look at it, you will find at least one right of the patient embedded somewhere. Then state laws. The first one, acts of the National Assembly. The second one, state laws. Persons living with HIV and AIDS law of Lagos State, 2007. Compulsory treatment and care for victims of gunshot laws of Rivers State, 2022. These are state enactments reflecting, of course, the Federal Act. Next slide. The third source, Code of Ethics for Medical and Healthcare Professionals. We have the Code of Ethics for doctors, medical ethics. We have Code of Ethics for nurses, Code of Ethics for laboratory scientists, pharmacists. Every healthcare discipline you can think of, they have Code of Ethics regulating how they should attend to their patients. So within those Code of Ethics, you can distill patients' rights. Next slide, please. We have another source, subsidiary legislation, regulations, and policy frameworks of relevant government agencies to protect patients' rights. We have, of course, the Patients' Bill of Rights 2018 by Federal Ministry of Health and the Consumer Protection Commission. Then, I doubt if a lot of people know about the next one, Standard Minimum Guideline for Human Rights of COVID-19 Patients in Treatment Centers in Nigeria, 2020. This document or regulation was brought up by the National Human Rights Commission. Then we also have the coronavirus, that's COVID-19 Health Protection Regulation 2021. And all these fall within regulations, policies of government. Next slide. now substantive law, which is our domain. Some patients' rights are also derived from substantive law, such as the Constitution or constitutional law. Then, law of contracts. Of course, we know that contract of medical service is a specialized kind of contract. For example, where a patient goes to the hospital and says that he wants to undergo plastic surgery, and he wants the doctor to bring his nose to his cheek, and the doctor assures and undertakes that that surgery will be carried out. Whether they know it or not, they are entering into a contract. There are express terms, there are implied terms, and one of the implied terms is that the doctor is going to give competent care. You are going to render competent quality healthcare service. So this is one of the sources of patients' rights. Then law of thoughts. Of course, the law of thoughts confers on a patient's right to self-determination. That's where we have patient's autonomy. The right to prompt, reasonable, and professionally competent medical care. Otherwise, liability will arise. So we have trespass to person, we have medical negligence or medical malpractice claims, or they are all from the law of thoughts. Next, please. Case law, decisions of courts, judicial pronouncements. Decisions of courts serve as a rich source of patients' rights. Below are some examples. So we have this case, 1914 case, Sklendorf against Society of New York Hospital. In this case, the court held by Cardoso J that every human of adult years and sound mind has a right to determine what shall be done to his own body. And a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. So no matter how well-intentioned the doctor might be, or how eager you want to save a patient's life, if you undergo a surgery, or rather, if you perform a surgery on the patient without the patient's consent, you are violating the law. You'll be liable. That's the position of the law. Then our own homegrown case, we have a medical and dental practitioners disciplinary tribunal against Okonkwo, where the court held the patient's right to refuse medical treatment on grounds of religious belief was recognized and upheld. So this is a Supreme Court decision. In this case, the woman belongs to a religious sect that does not receive blood transfusion. And they clearly warned the doctor, we do not want blood transfusion. The doctor did his best, but because blood transfusion was required and the patient has said, I do not want to receive blood, the doctor was stuck. He couldn't move further in providing care. Eventually, the patient passed and the people sued the doctor. They reported the doctor to Medical and Dental Council, and the Medical and Dental Council disciplined the doctor. He appealed to Court of Appeal, eventually to Supreme Court. Court of Appeal overturned the decision, and the Supreme Court upheld the decision of the Court of Appeal, respecting the right of a patient to decide what should be done to his body, including whether or not to receive blood to be alive. Next slide, please. You say, why patients' rights exist in Nigeria? It is expedient because we are now looking at, we have seen the sources, we have looked at international conventions or covenants, we have looked at our domestic laws, both acts of the National Assembly and state laws, we have looked at codes of medical profession, we have looked at regulation, we have looked at case law. So we are now looking at these rights, which of them are applicable in Nigeria? So while patients' rights exist in Nigeria, it is expedient to note that these rights are not, that should be not, please, not contained in a single document. And that is one of the challenges we have in enforcement. Our patients' rights are not contained in a single document. As we have seen, we have some in the National Health Act, we have some in the Compulsory Treatment and Care for Victims of Gunshot, there are some in the HIV/AIDS anti-discrimination law, there are some in different other legislations. So here are a few that are applicable. One is right to life. Of course, we already know Section 33. You say you will observe that the expression right to life is in the exception to right to life, rather. In Section 33, it does not include death by medical negligence. It does not include death by medical malpractice. It does not include death by receiving or by a rights violation or death by receiving medical treatments. If you read Section 33, the section guarantees right to life and gives us exception to the right to life. And in those exceptions, death by medical negligence is not one of those exceptions. Death by medical malpractice, death by violation of patients' rights is not one of those exceptions. Look at the case of Odafe and others against AG Federation. Next slide. In this case, the court upheld the rights of patients, of inmates to health care. And denial of those rights was tantamount to deny abuse or violation of their right to life. Then we have looked at African Charter, Chapter 4 of it guarantees right to life. Nigeria has also incorporated African Charter into its laws, and that's the decision of the court in Obani against Director SSS. Then we look at Article 6 of the International Covenant on Civil and Political Rights, to which Nigeria is a signatory. It guarantees the inherent right to life, calling for its protection by law and policy. Next slide, please. Second right is right to information. This right is provided under Section 23(1) of the National Health Act. You can also find it in Section 19 of the Code of Medical Ethics. You also see it in the Patient's Bill of Rights. So, patient's right to health, what right to information, what information are you supposed to give? Information as to the nature of ailments that the patient is suffering, information as to the treatment options or diagnostic procedures available, not just the treatment option that your facility can provide. You also give information as to the benefits, the risk, the costs and consequences that are associated with each treatment option. Then you also inform the patient that he has a right to even refuse treatment, provided you explain the implication that all these things I have said, okay, if we used option A to treat you, there is a likelihood that you will go deaf on your left ear or one of your ears. If we use option B to treat you, there's a likelihood that you will remain paralyzed for life. If we use option C, you tell them the cost implication, you tell them the risk, you tell them the benefits. Then most importantly, you tell them that they have a right to refuse any of the options, because the patient is the master and lord of his body and can determine or should determine who, where, and how that body should be touched. Next slide. Then another important component of right to information is that that right should be given to the patient as much as possible in the language the patient understands. That's the provision of Section 23(2) of the National Health Act. Next. Right to informed consent. Informed consent simply means that the patient has been given information and the patient now makes up his mind, makes a choice of what treatment procedure to be used on him or her. That choice of the patient and subsequent authorization of the healthcare professional to commence treatment is what we call informed consent. You will see this under Rule 19 of the Medical and Health of the Code of Medical Ethics. It's also provided for under the Patient's Bill of Rights. Then that consent must be freely given. I got this acronym. FRIES must be freely given. It must be reversible, meaning the patient can withdraw the consent at any time. That consent must be informed. If you see practices, particularly when people are being wheeled into the theater for surgery, they'll just say, Madam, sign here. They'll bring a form. The person wants to be alive. The patient will, of course, sign. But that consent is not informed. You have not explained to the patient what you are going to do to his body. You have not, or her body, you have not explained to the patient the nature of surgery you want to undertake. You have not told it, you just say, sign here. The patient signs. Now, there is a consent form that has been signed by the patient, but I can tell you free of charge that if that is challenged in court, the court will invalidate that consent as not being informed. Then the consent must be emphatic and specific, meaning if you give consent for the operation to be done on the left eye, the doctor should not, out of pity or out of best interest for you, the patient's, out of his magnanimity for the best interest of the patient, go and operate on the right eye. It has to be specific. If you say we are amputating the left leg or left limb, it has to be that one. That was the position of the law in the case of Okekaro against Tanko. Here, a surgery was done and a finger was chopped off that the patient didn't consent to. Next slide, please. Next slide. Okay. Right to treatment in emergency or right to emergency medical treatment. This is one of the innovative sessions or provisions of the National Health Act, as far as I'm concerned. Now, it provide I deliberately brought out the provision of the section here. It says patients should not be refused treatment in an emergency situation for any reason. Any reason includes that you need to go and deposit first. Any reason could be that pay 50,000, go and buy card. Any reason could be that the doctor that is supposed to attend to you is not here. I am interpreting the law as it is written. Any reason could be that we are on strike as they currently are now. But the law is that patients should not be denied treatment in emergency situation. Is it emergency? If it is emergency, treat the patient. Now, what is emergency? Cardiac arrest is emergency. Snake bite is emergency. Accident is emergency. Labor is emergency. So once it is emergency case, you waive the hospital protocols of going to buy card, making deposits, and all that to save life first. Now, subsection 2 says that where a hospital violates subsection 1, that such doctor or nurse or healthcare professionals, we pay a fine, if found liable, of course, we pay a fine of 100,000 naira or imprisonment not exceeding 6 months or both. And the question I usually ask whenever I'm discussing this session is, imagine that a doctor is sent to prison and someone asks, hey, yeah, it's a doctor, what did he do? How can a doctor go and steal? And they say, no, he didn't steal. Oh. What did he do then? They say he refused to treat a patient in emergency situation. That's the provision of our law. Now, I must balance this with the provision of section 11 so that, okay, before I go to section 11, I need to put it on record. What the law says is treatment, emergency medical treatment. It does not say free medical treatment. There are two different things. Our law, as it is now, does not provide for free medical treatment. So, as a patient, if we are talking about rights, we must also talk about duties and obligation of the patient. As a patient, one of your responsibilities is to pay for medical services rendered. So you cannot go to hospital and say that the law has given you right to free medical treatment. No, you should be attended to in emergency and you have the responsibility to pay for treatments received. That is the law. Then we have compulsory treatment and care for victims of gunshots act. Section 1 of that provision of that law says hospitals, private or public, should accept or receive for immediate and adequate treatment persons with gunshot wound with or without police reports or police clearance. So this law has been in effect since 2017. Unfortunately, till today, some hospitals still demand that patients, victims of gunshots, should go and produce police report first before receiving treatment. Now, that is no longer the position of the law. For our beloved healthcare professionals who are part of this webinar, this is the provision of the law. Persons with gunshot wound shall be received by any hospital in Nigeria for immediate and adequate treatment with or without initial deposit of funds. Now, that's the provision of subsection 2 of section 2. The first one is section 1. The second one is subsection 2. Under section 1, you must treat with or without police report. You don't even require it. Then subsection 2 says you must treat with or without initial deposit of fund. Now, the question that will be agitating your mind now will be, so if they do not deposit, how will the doctor or hospital treat without initial deposit of fund? Where will they get the money to buy the consumables? That brings us to section 11. Next slide, please. That brings us to section 11 of the National Health Act, which provides for basic healthcare provision fund. Now, under section 11, a percentage, 5% of that money is to be used to cater for emergency medical treatments. I can tell you authoritatively that that fund is already being disbursed. 2 days ago, I was at a technical session preparatory to the World Patient Safety Day, which was celebrated yesterday. That session was organized by the Patient Safety Desk of the Ministry of Health. Now, one of the officials was angry that these funds are being disbursed, but the challenge they are having is people are even coming to make false claims. There's okay, treat patients. When you treat, put in the number, the name, phone number of patients, send in the persons you have treated. When the ministry now begins to call, okay, Mr. Kingsley, how are you? We understand you received a treatment as ABC Hospital. And the person say, no, sir, nothing happened to me. I didn't, no, it's not me. You are talking to a person. So you see why we say the government is not doing. The ones the government have decided to do or have started doing, we are using corruption and criminal tendencies to frustrate it. Initially, I used to argue that section 11 Initially, I used to argue that section 11. Please, what happened to my slide? Hello, technical people. Hello, Dami. I can't see my slide, please. Okay. I used to argue that Section 11 was not implementable. How will it be implemented? And someone told me sometime last year that they have already started. He is into air ambulance and emergency ambulance services. He told me, Barrister, this thing, no, we have been receiving money. My company have been receiving money. When there are emergencies, we send ambulance, even air ambulance, and later we are reimbursed. And let me shock you, the first 48 hours of that incident, be it accident or what, the federal government writes off the bill for the first 48 hours. Now, this information is not in public domain as it ought to be. And that is where I usually quarrel with National Orientation Agency. Very soon, election will start. Our election campaign will start. And you begin to hear jingles around, do not buy voters card, do not sell your vote. Very soon, we are gradually moving into dry season. You will begin to hear jingles, do not engage in bush burning. You will hear jingles, do not vandalize government properties. But I have always asked, when have you heard jingle, whether in English, pidgin, or your local language, telling you your rights as a patient, or that this Section 11 I'm talking about, that the government has started implementing it? The government is implementing it. So when the government says treat with or without initial deposit of funds, the government have put a system in place for the hospital to be reimbursed of that money. Within the first 48 hours, the government writes off the bill. I can tell you that authoritatively. Right to respect to dignified care provided under Section 2B of the Compulsory Treatment and Care for Victims of Gunshots. Go to number 5, please. The rights. Just give me a few minutes. Let me change the power source. My laptop is showing me that the battery is going down. Let me just plug it somewhere else. Okay, sorted. Thanks, please. Okay, right to dignified care, respectful and dignified care. Section 34 of the Constitution, of course, dignity of human person. Section 2B, Section 2 Sub 2B of the Compulsory Treatment and Care for Victims of Gunshot Act 2017, Rule 11D and E of Code of Medical Ethics 2008, Patient's Bill of Rights. These are all the sources of this particular right of the patient. This includes freedom from torture, physical or verbal abuse, discrimination of or any act that will make the patient feel stripped of his or her dignity. Anything that will make the patient feel less of himself done to him by a healthcare professional is a violation of these rights. Still on the technical session we had 2 days ago, my joy, I told them that my joy is that what we have been echoing from outside is being, what we have been shouting from outside is being re-echoed from inside. We outside lawyers, inside being the healthcare professionals. And they were the ones talking and saying, this cannot continue. We keep receiving reports of verbal abuse by maternity patients, our mothers, our sisters who go to deliver. They are standing on the borderline of life and death. And that is not when you be telling them, Madam Push, was I there when you were doing it? That's an abuse. That woman is in pain. She's battling for her life. All she needs, if you want to ginger her to push, there are better ways to do that. Next, please. Okay, let me look at, before you move, don't go first. Look at this. A person with gunshot wound, not wound. Go back, please. I want to read that provision. A person with gunshot wound shall not be subjected to inhuman or degrading treatment or torture by any person or authority, including the police or other security agencies. You know, the issue of gunshots or request for police report was actually a decree of the military era. But as Nigeria is today, individuals have fallen into the hand of armed robbers. We have seen cases of stray bullets. Someone is going on the road innocently and a stray bullet hits this person. Then the person is rushed to hospital. Rather than receive dignified care, the person is being questioned. In fact, as he's coming, he's being suspected to be a criminal. And that suspicion and your attitude towards the person could strip that person of his or her dignity. Next slide. Okay, we are going to run a bit faster. Rights to privacy. I commend healthcare professionals on these rights. This is one of the rights they have gotten almost 100% in most places. Now, let me explain. If you walk into a hospital ward, you will see different colors of screen, curtain like a shield that has a ruler under it. They will just bring it and cover the bedside of a patient, particularly those that have some kind of wound and they want to undress the patient or treat the wound. They will use that screen to shield the patient from being seen by others. They are respecting these rights to privacy. That the patient's body should not be open to the viewership of anybody who the next patient by the next bed. So I commend them for this. Next, please. Next slide. Okay, rights to confidentiality of medical records. We look at section 26(1) of the National Health Act. Section 26(2) of the National Health Act provides the following exception. Of course, where the patient consents to the disclosure of in writing. So it's not just, okay, disclose. The patient must consent in writing that his or her medical record should be disclosed. Where a court order requires that disclosure, then in case of a minor with the consent of a parent or guardian, then in case of a person who is otherwise unable to grant consent upon the request of a guardian or representative, then non-disclosure of this information represents a serious threat to public health. Example, Ebola or COVID. If someone is suspected to have COVID or have been treated of COVID by a healthcare facility, they owe the public the duty to disclose that they have treated Mr. A, B, C of COVID, and then put the public on alert so that measures could be taken to curtail the spread of that particular epidemic. Then Rule 8B, paragraph 2 of the Code of Medical Ethics, it places doctors on a duty. They have a duty of absolute confidentiality on all he knows about a patient, even after the patient has died. Even after the patient has died. Then Rule 9F of the Code of Medical Ethics, the communication between a doctor and a patient in course of treatment should be treated in strict confidentiality. Of course, the exceptions are also part of what we have looked at, principle of which is the patient's consent. Next. Okay, please go back since I skipped that slide. Okay, next. We look at section 11. We are talking about confidentiality. Section 11 of the HIV/AIDS Anti-Discrimination Act, it prohibits healthcare professionals from disclosing the health status of a person living with HIV/AIDS without the person's consent. Then we look at our Data Protection Act. It treats health data as a sensitive personal data. If you look at section 30G, there are exceptions. So the personal information or medical record of a patient is confidential. These are laws that guarantee that right. Next. Okay, right to obtain medical records, section 23, 1A and B of the National Health Act. Then we also have the Freedom of Information Act. Now, note that the Freedom of Information Act applies only to government institutions. So you cannot go to a private hospital and rely on that Freedom of Information Act. But for for section 23, 1A and B of the National Health Act, you have a right to obtain your medical records. Now, I don't want to go into the debate of who owns the record. That's a long academic debate. Then, right to decline or refuse treatments. We've talked about this right. Now, this case of Cedar Way against Board of Governors of Bethlehem Royal Hospitals, a 1985 case, it's a foreign case. In that case, Lord Templeman said, the patient is free to decide whether or not to submit to treatment recommended by the doctor. If the doctor, making a balanced judgment, advises the patient to submit to the operation, the patient is entitled to reject the advice for reasons which are rational or irrational or for no reason at all. The patient can say, I don't want treatment. Then you say, why do you not want treatment? You say, I have no reason. That's a right to refuse or decline treatment. Next, we'll also look at, we have also mentioned the Medical and Dental Practitioners Disciplinary Tribunal against Okonkwo in that regard, where the Supreme Court also upheld that right. Then another right is right to terminate medical service against medical advice. Section 20 of the Code of Medical Ethics. As a patient, you have a right to terminate medical service. You are in the middle of treatment. You can say, I don't want again, please. I don't want again. In 2019, I resolved a case between a patient and a tertiary healthcare facility. And the woman was undergoing dialysis. And the way and manner they were handling her, she said she's not doing again. She quit the dialysis. She went to another facility. The second facility said their generator is down and their medical and their dialysis machine will not work because there's no power. So then I wanted to sue the first facility. When they got in touch with me, after examining the case, I informed the young man. I said, we will still be in the process of filing a suit for your mother. Your mother will die. So why don't we harness alternative dispute resolution? And he was wise enough to agree. We spoke with the hospital. The CMD gave us appointments. We went. And the matter was resolved. As far as I'm concerned, it was a win-win situation. Why? Because for the first time in my practice, I saw a CMD apologize to patients. That was the first thing he said. As soon as he heard the young man after his complaint and all that, he said, please, sir, we are sorry. We are sorry. And you do not want to imagine how magical that word was. All the tension in the air disappeared. The CMD said, where is Mama? I said, Mama is at home. She says she's not doing again. She's not coming for treatment here. And the CMD said, go and bring her. Going forward, we will treat her at no expense. She will undergo her dialysis at no cost to her. And it was a win-win. The next right of the patient is rights to transparent billing. You find out rights under Section 11B of the Code of Medical Ethics and also under the Patient's Bill of Rights. Now, interestingly, this Court of Appeal case, Mr. Jonathan Tena Agwan against Benue State University Teaching Hospital. That's the appeal number there. In this case, very funny. A man took his son to the hospital, and the hospital made some prescriptions, and one of the consumables prescribed, the hospital did not have it. The man went outside the hospital to buy that particular consumable. When his bill was being prepared, we are talking about right to transparent billing. When his bill was being prepared, the hospital included that bill of 2,500 naira into the man's bill. That cost of 2,500 that the man spent outside. And the man said, no, I bought this thing outside, not from your hospital. The hospital said that's their policy. The man said, okay, let me go. I will come back and bring the money. The hospital said no, they detained his child who actually came to receive that care. And the man went out of first instance, agreed with the hospital. And the man appealed. We're talking about 2,500 naira. And the man appealed. On appeal, the Court of Appeal, Benue Macaulay Division, overturned the decision of the High Court and awarded damages of 250,000 naira in favor of the man, the appellant, and also ordered the hospital to refund the initial 2,500 they collected, which caused the whole of this litigation. So transparent billing requires that as the patient is receiving care, the hospital is informing the patient per second, per minute, as each consumable is used, as each medication is used, as the patient undergoes each procedure, the patient is informed, okay, this surgery costs 10,000. Then tomorrow, you now give injection. The syringe and needle we use for the injection is 500. The man now knows that syringe and needle, his bill is 10,500. He follows on with the bill until you discharge him. If you now give him bill of 275,000, he will not be angry. He knows how he accumulated that bill. So that is the right to transparent billing. Right to quality care, we already know, Patient's Bill of Rights. Right to visitation. Now, a patient has a right to visitation by family, by friends, by this is psychosocial healing. By this support is very important to a patient. However, this right must be subject to the hospital's time. You do not say because you have right to visit them by 7 or 8 or 10 a.m., you now come and insist that you must see your brother, whereas the hospital's visitation time is from 3 or 4 to 6 p.m. So you will be the one violating the hospital policy. So this right is subject to visitation time of the hospital. Next, please. A patient has a right to clean, safe, and secured healthcare environments. Now, this right is provided under the patient's Bill of Rights, so as hospital-acquired infection, where you, the healthy man, has gone to hospital to see your brother, and you leave the hospital with an infection you don't know you have or you acquired, or a case where the patient is admitted for one ailment. Before you are done treating the patient of that ailment, the patient is leaving the hospital with another ailment, another infection. So a patient has a right to clean, safe, and secured healthcare environment. There have been reports of cases in this country where armed robbers go to hospital, rob doctors, rob patients. That's a violation of the patient's right to secured healthcare environment. If the patient sues, the patient will recover damages against the hospital. I have posted videos on Facebook where a hospital setting, a hospital ward, monkeys are jumping. In fact, that video, I was cringing as I saw that video. There was somebody there receiving a drip. Somebody was being transfused. Now, if the monkey jumping from one end to another goes to pull that line, what happens to that patient? That environment was not secure. That environment was not safe. There are videos of dilapidated healthcare facilities, particularly our primary healthcare centers and even some secondary healthcare centers. You see the roof is almost collapsing. I saw one video, it was raining and rain was pouring into the hospital ward. Such healthcare environment is not safe, it's not clean, and it's not secured for the patient. Then a patient has a right to religious observation or observance. Whether you're a Christian, whether you're a Muslim, whether you are African traditional religious worshiper, you have a right to observe your religion, because faith also plays its role in healing. We all believe in the supernatural and that there is a being to whom you can talk and he will intervene. So you do not tell a patient that you cannot observe your religious prayer time as a healthcare professional. But that right too is subject to the treatment regime that the patient is receiving. So you too, as a patient, you cannot come and insist that your church has night vigil this night. You must go and attend that vigil. Or that today is Salah, you want to go to the mosque to pray today. You have two choices. One, either to stay back and receive your treatment fully, or you apply your right to be discharged against medical advice. Then you'll be discharged and you go home. The same thing is applicable. I forgot to emphasize this when we talked about right to emergency medical treatments. We have seen videos circulating where patients are brought to hospital and they are practically dismissed. As far as I'm concerned, that's dismissal. Now, that is not medical service. That is violation of the patient's rights to emergency medical treatment. What the hospital is supposed to do, of course, the position of the law is that you should not refuse patient treatment in emergency situation for any reason whatsoever. However, reality tells us that there are reasons, valid and cogent reasons, why the hospital could deny a patient treatment. But it is not denial in the real sense. What the hospital is supposed to do is to refer the patient. Now, referral is proper and valid medical treatment.
Mr.
The
Speaker, I'm
culture of...
sorry. Let me quickly
Yes.
remind you that we are almost running out of time.
Okay, just
And
give me
we
10
also
minutes.
need
I'll
to
be
take
done.
some
We will be done
questions
with
before
today's...
we. It's all right.
Yes,
Thank you.
in less than 10 minutes, I'll wrap up
It's all
for
right.
today.
Thank you.
You're welcome. So, for referral, you are supposed to have examined the patient, then write a referral note to the facility you think that has the capacity to attend to that patient. Yes, this hospital might not have a consultant in this area. So you do not just dismiss the patient. Madam, no. Go to the other hospital. No, that is not referral. That is dismissal. I just felt I should emphasize that. Then a right to lay complaint, if dissatisfied, Section 30 of the National Health Act provides for that right. Then Patient's Bill of Rights also guarantees same. So you have a right to lay complaints. When we discuss redress mechanisms tomorrow, then we look at how to lay complaints. Next slide, please. Okay, you have a right to freedom of movement and freedom from detention. Section 41 of the 99 Constitution and Rule 20 of the Code of Medical Ethics guarantees this right. Now, this case, Mrs. Ngozi Osegban won order against the registered trustee of the Synod of Diocese of the Niger. The suit number is the unreported. This is a 2017 case. In Anambra State, this hospital is owned by a religious body, and the woman took her 11 months old child to that hospital for treatment. 11 months. The baby passed on. And this family, she and her husband, are mourning the loss of their 11 months child. And what was paramount in the mind of the hospital was for them to pay the accumulated hospital bill. They didn't say they won't pay. They say, give us time to put ourselves together, raise this money and pay. The hospital detained them and detained the corpse of the baby. And they went to hospital. They went to court. They were detained for more than 10 hours, and they went to court. And the court granted them 500,000 naira against the hospital. The court awarded damages of 500,000 against the hospital. So, for my respected doctor and healthcare practitioner friends who are on the call today, there are civil ways of recovering your debts. One of that is not detention of patients. I resolved the case in 2018. Oh, yes. I was on air. I was on a live program on radio. It was a phone in, and someone phoned in that a hospital in Lagos was detaining his wife and his newborn baby. That baby was 3 weeks old as at the time the man phoned in, because they were owing 70,000. The CS cost 200,000. They had paid 130,000, remaining a balance of 70,000. And the doctor still did not allow them to go home. The next part is that this woman had 4 children. That was the 4th delivery by that particular doctor. The man ran from Lagos to Abuja in search of 70,000 to go back and pay. How much was his transport coming? So when he phoned in on that program, after the program, we started calling back all the people who phoned in. Started calling, and we got to him and said, what you said, is this true? Say yes. Say, give me the number of the doctor. Or firstly, give me the number of your wife. I called the woman, she corroborated. I called the doctor, he didn't deny. And I told, it was a Friday. I called him around 7 p.m. I said, sir, I don't know the part of Lagos they are, but I'm appealing to you. That child should not remain in your hospital by 11 a.m. tomorrow morning, Saturday. He said, whatever you like, I don't care who you are. Is that how they want to pay me? I said, well, I don't know what you're talking about. Not make a newborn baby a prisoner because of money. You cannot turn a newborn baby to a prisoner. And that's how the following morning, before 11 o'clock, the woman called me that the doctor had released them. I told him how to go about to recover his money. Then lastly, for today, we will continue tomorrow. You have a right to continuity of care. We have talked about right to discontinue care. Now you can terminate your healthcare service reception. And if you change your mind, it is your right to go back to that same doctor and say, doctor, I'm now ready, continue treating me. And the doctor must not refuse you, except where you are violent to the doctor, because doctors are also human beings. If you pose a threat to the doctor's safety and the safety of the hospital environment, they have valid right to deny continuing your care. If you go there insulting them, making them look like fools because you have a right, they also have a right to deny you treatment. So we'll stop here for today. Tomorrow we continue. Thank you very much for your time. Over to you,
Thank you
Madam.
so much. Thank you so much, Ebenezer Egwat. So I believe we all will attest to the fact that our speaker did justice to today's topic. I urge us all to keep reflecting and putting into practice the key takeaways and the insights from this webinar, this presentation. Right about now, distinguished participants, I'll be going through the chat box to read out the questions we have from there. We have a question from Michael Babajide. He says, which body of law deals with and comprehensively defines civil and criminal wrongs that a medical practitioner can be liable for?
Okay, that's a brilliant question. Thank you very much. I was careful not to delve into the realm of medical negligence. I had to restrain myself seriously. But which law defines the liability of a doctor, a medical practitioner, whether it should be civil or criminal, is the fact, the circumstance of each case. No two cases are the same. For example, some persons, some authors use medical negligence and medical malpractice interchangeably. It shouldn't be so. Where medical malpractice is a departure from laid down standards of medical practice. For example, where a patient goes in for surgery and the doctor steals, I chose that word carefully, steals or harvests the organ of the patient without knowledge, steals one kidney of that patient. That is medical malpractice. It is a criminal offense. So it falls under criminal litigation. Where we know abortion is a crime in Nigeria, except where it is procured for the purpose of saving the life of the mother. Where a doctor, in the course of trying to conduct abortion that is not authorized and the patient dies, it's a criminal offense. The doctor goes in for that. Now, you are still dragging me to what we will discuss tomorrow, remedies. Please, I implore the person who asked this question to come in tomorrow when we will discuss legal remedies. Then, for civil or still on criminal, where there is issue of euthanasia too. Euthanasia is outlawed in Nigeria. Mercy killing, at least active euthanasia, is outlawed in Nigeria. So where a doctor engages in that, all these are medical malpractice, as opposed to medical negligence, which is a mistake or error of the doctor, where a doctor makes a mistake and it doesn't lead to loss of life, but it causes the patient harm. It can go for civil. For example, you injected a patient a wrong dose and it leads to loss of hearing of that patient, or even injected a wrong medication and it leads to loss of hearing of that patient, that's a negligent case. It can go for civil suit and the patient can claim damages. So I need you to understand it is the fact of each case that determines whether it lies under criminal or civil litigation. Thank you.
Thank you. We also have a question from Chisom Obasi. She says, what does the law say about a dying patient's consent to donate their organs after death?
Yes, it is valid. I think section 50 of our national, either 50 or 55, within that range of our National Health Act provides for it. You can donate your organ in Nigeria through your will. You can write it, put it down that you want your organ donated. Yes, it can happen.
All right. Thank you so much, Mr. Speaker. Let me quickly invite our technical expert, Damilola Alabi, to help us read out the questions we have from our YouTube channel. Damilola, over to you, please. Thank you.
Okay, thank you, Dr. Amara. So, thank you, Dr. Amara. So, my network has been pretty inconsistent. So I'm checking YouTube. I can't see any question, at least not for now. So yeah.
It's all right. Thank you so much, Damilola Alabi. Let me quickly invite the chairman of the Medical and Health Law Committee.
Can we give anybody? I think I saw one question. I would like us, if there is anybody who has this one. No, it is not. You say it's still in our laws for next of kin to sign for a patient before an operation is conducted on the patient. I want to believe that is it still in our laws? It was never in our laws. Those are vestiges of custom where you say, I am the man, the husband has to sign for the wife. The patient, if the patient is an adult of sound mind, we said you are the person that will determine what should happen to your body. Now, where the patient is unconscious, where the patient is incapacitated and is dull incapacitated and cannot give consent, somebody we have defined, if you joined us from the beginning, we talked about user. So the person's relative can give consent on behalf of the patient. But it is not that if the patient is a minor, the father can give consent, except for maybe exceptions like Gillick competence, which applies to ladies. I feel it is discriminatory though, in terms of if they are seeking reproductive treatment. So that is it. But by law, there is no law that says the husband or a relative of a patient, an adult patient of sound mind, must give consent before a medical treatment can be done on the patient. No, we don't have that law, sir. Thank you.
Thank you so much, Mr. Speaker.
I hand over to you, Madam Moderator.
Thank you so much, Mr. Speaker. I can as well see some comments, though they are not questions from Badagubi Adamu. Thank you so much, Adamu, for your comments. Let me quickly invite the chairman of the Medical and Health Law Committee of the MBA Abuja Gariki branch, Ebenezer Egwatu, to give us a closing remark. Mr. Chairman, please.
Okay, doctor, apologies. I can see someone's question. I don't know if you saw that.
Okay.
Okay, so there's a question from Olumuyiwa that says, is it still in our laws for next of kin to sign for a patient before an operation is conducted on the patient? I don't know if you have seen that or answered that.
Yes, I just addressed that particular question. I just addressed it, but for the purpose of emphasis, It is not in our law. It was never in our law. Next of kin should sign where the patient is not in a position to give consent. So let's get the procedure. The patient is the Lord and Master of his body under the principle of patient autonomy or self-determinism. Now, where the patient is an adult of sound mind and is in a state where he or she can speak and give consent and conscious, the patient will give consent. Where the patient is an adult of
someone's hand
unsound
is
mind.
up. I think he wants to make a contribution.
Okay, awesome.
So, I don't know if you'd like to take that.
Yes, please.
Okay, so Mr. Clement, you can unmute.
That's Prof.
Okay,
Please.
Mr. Clement, you can unmute your
Okay.
mic.
All right. Thank you very much, Ebenezer, for your very lucid
Good evening,
presentation.
sir. Thank you, Prof. Thank you, sir.
Okay, well, good afternoon from here, or good morning, really. All right, thank you very much for your very lucid presentation. I dropped some comments. Like you talked about the Tanko's case with Dr. Rom Okekero. That brought a number of things regarding minors. Nikki Toby then spoke to the fact that a child of 14 years, that was what happened in that case, really. The boy had told the doctor, why don't we observe this finger to see if it will survive? So the doctor, rather than listen to the Tanko, called the aunt who was there and called her to the theater door to say, well, this is what is happening to the finger. And the woman said, yeah, you are the expert, do what you think is right in the circumstance. So the matter came for determination after the amputation of the digit. So certain facts came out from there that the minor can actually give consent. That's why I posted something on the platform. If a minor is mature, what we call it mature minor doctrine, can give consent. That would yes, that would the Nikito be saying in that case. Two, that the consent obtained by the theater door, a verbal consent for that matter, will no consent at all. That's another point that came out from there when you talk about informed consent. Informed consent ought to be that the patient has had time to think about the procedure. Even if the aunt was the one qualified to give the consent in the circumstance, but the manner in which it was obtained, calling her to the theater door and obtaining a verbal consent for something as serious as amputation of a digit, Nikitobis then, as you know, said that was no consent at all. So those are the facts that came out from that case, that a minor that is mature can give consent. I also thought we should have probably mentioned where we have challenges, the issue of minors indeed. Minors indeed, that way we have challenges. What rights they have, how do we protect it? Now, the case that happened, Sigbuno and Chevron.
Yes.
Yeah, so, we also need to highlight that, parents, for example, can make themselves martyrs of the gospel, but they do not have that right to make their minors indeed to be martyrs. That case went up to Supreme Court, and the Chevron and Dr. Fawaya, they won that case against the parents of that child. How to do blood transfusion. The child was going to die, but the company insisted that the child shouldn't die, and they gave the blood. So the matter went to court. So we also needed to probably chip that
Thank you,
in.
Prof.
Thank you very much.
Let me just add that. Thank you, Prof. We appreciate your sacrifice to be joining this webinar, sir. We appreciate that, sir. We appreciate it. And thank you also for not just being a silent observer on the call, but bringing this out. For minors, there's a procedure. The minors cannot give consent, but where the life of a minor is threatened if nothing is done, the doctor will approach the court to get an order. In fact, it's a duty under the Code of Medical Ethics for doctors to do all they can, all that is within their power to save those who cannot give consent, particularly minors. So in the case Prof cited, the doctor approached the police went to the magistrate and got an order. The parents of that baby belong to a religious sect that does not receive blood transfusion or subscribe to blood transfusion. And the court gave an order, and the doctor treated the patient, the minor. And the parents sued the doctor, the magistrate, and the police officer. And that case went up to Supreme Court. And the court held that that little baby, firstly, the life of that child belongs to the state. One. Secondly, that child has no religion. So you cannot confer or use the tenets of your religion to deny a child his or her right to life because your religion does not receive blood transfusion. I actually witnessed a pathetic case in 2010. A young boy of 14 years jumped from a first-story building and landed on, you know, where they are building, there's this heap of sands. So when he landed on that side, he didn't know that an iron was buried on that sand. As he was landing, that iron pierced to almost his anus to his intestine, and was brought for surgery. The name of that young man is Wisdom, and they believe the mother, particularly the father, they are this sect that does not receive blood transfusion. In the morning, they will gather within the hospital environment. I was nursing my uncle within the hospital for 3 months. They will gather and say, hi, if this is only what money can solve. And the hospital is saying, this boy has undergone the first surgery without blood. He has undergone the second one without blood. This one, we need blood transfusion. And they say, release the boy. In fact, I engaged the mother. And the mother told me, Ebenezer, the Bible says that whoever sins, every soul that sins shall die. This boy is a soul. In fact, he's even lucky to have reached 14 years. What about those that die at 2? What about those that die at 4? The hospital discharged them. They even recommended that the hospital can use erythropoietin to conduct the surgery. And the doctor said, no, there is no oxygen in erythropoietin. So we need blood. They say discharge us, that they have a member of their sect in another facility that will conduct the surgery. They discharged them. They went there. As they opened that boy in the theater, he died. And you know the most annoying and hypocritical part? Their in-law, Chiboy, who was my friend, we kept following up. I said, how far? How is Wisdom? The guy said, Wisdom, don't die. The following day, I called the mother. He said, how was the surgery? He said, hi, we thank God. It was very successful. So how can you be deceiving yourself? Now, I do not have a personal problem with you and your religious belief. But what the law has provided, and we know who a minor is, anybody who is under the age of 18 years in Nigeria is a minor. So going forward, if you are here, you have relatives, please, the part of the reason you attended this lecture is not just to get CPD points, but to gain knowledge. So help us spread the good news. Thank you very much. Having said that, Cyril Ojono, okay, I will give you 2 minutes to just make your contribution. Then please, we will reconvene tomorrow. Very important. Tomorrow's webinar is by 10 a.m. I forgot to bring this to our notice. Tomorrow's webinar is by 10 a.m. to 12, not 3 to 5, because our branch meeting is holding by 4 p.m. tomorrow. So that's why we moved the webinar from 3 to 10 a.m. Thank you. Mr. Cyril, please, 2 minutes.
Unmute.
Hello, Mr. Cyril. Yes.
Unmute me. Okay. They were not allowing me to unmute. Okay. Can you hear me now, please?
Yes, sir. Yes, sir.
Yes, we can hear you.
Please, Chairman, thank you for giving me this opportunity.
My Oga, well done, sir.
I just felt like listening, although I just stumbled into this thing just late into the program as I was going through my calendar. I just want to say maybe that would be for tomorrow.
Okay, sir.
The discourse that was had just recently, from the perspective of the child, the right of the child.
Yes.
I was just thinking aloud to myself, now with the Child Rights Act,
Child Rights Act, they have the right
with this same situation that occurred with the child that died as a result of what I'll call negligence of his parents, maybe based on religious, whatever it is, I don't care. Will a third party, like any of these human rights bodies or others, be in a position
Yes.
to sue on behalf of
Yes.
that lady?
Exactly.
That's
Yes.
the
Yes.
question that's
Yes.
going to my
Yes.
mind.
Yes. Yes.
Because
The National
there
Health Act.
has to be deterrent, so that if you want your religion, just like some people say education is bad, is not this thing. Yeah, you have a right to have that view. But when it impacts negatively on a person or a people, like in this case, the death of a child, will you be allowed to go free by society? You use the word that the court said the child is a property of the state, that child. So will the people turn an eye and say, okay, it's your child, the child is dead, so let everything go back as normal, which is what must have happened in that case. Under the current circumstances of Child Rights Act, will we be able to allow such a situation to still hold or still subsist? That is my,
No, sir.
maybe by
No,
tomorrow.
sir. No, sir. But tomorrow we will start with this.
Yeah.
Start from here, because I don't want. We're already 2 minutes out of our setting. I don't want the platform to just shut us out. We need to do a few closing remarks. So we will start with this your question, sir. But let me say categorically, under the National Health Act, if we look at who a user is, there are third parties who can take up that case on behalf of that child. There are third parties who can take up that case if we go by the provision of the National Health Act. If we go by the provision of the Child Rights Act, the child is entitled as a right to health care. Now, this webinar is being organized in commemoration of World Patient Safety Day 2025, which happened yesterday. And the theme of this year's World Patient Safety Day is safe care for every newborn and every child, with the slogan, safe care from the start, right care from the start. So yesterday I was saying on air, child, because the first question they threw at me, why the child? I said, if we do not protect our children, we do not have a next generation. So, sir, tomorrow we will start from here. Thank you very much. Without wasting further of our, even though it was not a waste of time, I want to sincerely, heartily, on behalf of the committee, firstly, and by extension, the membership of Garki branch, register our profound gratitude to all the participants who have been here. Prof. Siri, thank you, Prof. And yes, you all say Prof now. Why? I'm apologizing. Prof. Clement, thank you, sir. We are most grateful. Prof is 7 hours behind us for you to understand the sacrifice. But even when I sent the link, he said, I will do my best to join, but give me a call, a reminder call. And he's here. Prof, thank you, sir. We are most grateful. My Dr. Teluchi, thank you. I am aware you are on the YouTube. Thank you, ma. Professor Esiri, thank you, Prof. We are grateful. Professor Liu is here. Thank you, sir. Professor Sonny is joining all the way from UK. Thank you, Prof. All my doctor friends, I am very grateful for your support. And you know, this is a family discussion we are having. It's not rivalry. I used to tell them that when we come for discussions as this, it is not an attack against the medical profession. It is not an attack against the person of any individual doctor, but it's our collective effort to have a functional healthcare system where we will go with assurance that we will come out alive, knowing that the practitioners will practice according to the ethics. Having said that, thank you very much. Good night. See you tomorrow by 10 a.m. We will start with Dr. Siri's question and proceed with other parts of it. Thank you.
Thank you, everyone.
Okay, thank you, everyone. So I will leave the meeting room open for the next 4 minutes. That will be 10 minutes after 5 p.m. And I'll keep reposting the CPD link. So please view the link. The link will only be active for the duration of this webinar. And for the people saying the link is not working, the link is working. The link has been filled by more than 100 persons. So the link is definitely working. So two things, either refresh your network or change your browser. It could be any of that, but the link is definitely active and working. So for the next 4 minutes, we'll leave the meeting room open. I'll keep reposting the link, so please fill the link. That's the only way for you to get your CPD points. And once this meeting shuts down, the link will no longer be receiving responses. Thank you.
I also want to thank our ICLE monitoring official for today. Thank you, madam. We are grateful to have you. And by extension, the ICLE director or the directorate generally for their cooperation. And for those of you who may not know, our webinar holds every month. Next month, we will talk about another interesting topic. I won't disclose that now. Thank you. We will hear about the topic tomorrow.
Yes, thank you all for joining. We still have 2 minutes before the meeting is closed. So I will keep reposting the CPD link. If you're yet to fill the link, please do that.
Both on YouTube
Once the
and on Zoom,
webinar
please.
is over, the link will no longer be receiving responses.
Whether you are on YouTube or on Zoom, the link is the same. Kindly fill it.
All right, so it is now officially 10 minutes after 5. And on this note, this is the final call. I'm reposting the CPD link for the last time.
Madam Onyinye, good evening, ma.
Okay. This. All right, thank you, everyone. Yeah, it's been a good one. So we hope you make time to join us tomorrow. Thank you. And we'll see you tomorrow.